In 1545, the word revision meant something almost scientific. A scholar examining a medical text a second time, catching errors, correcting dosages, making sure nothing would harm the patient. It was a word for people who cared about getting things right. No one could have imagined it would become one of the most powerful political weapons in history. Within a century, British royalists had hijacked the process, using revision to surgically erase 11 years of laws passed while the monarchy was overthrown. Not repealing them, not debating them, simply declaring they had never existed. And the American colonies were watching. They took that same tool and turned it on their own people, quietly closing legal doors that had once been open, dismantling protections that couldn't have survived an honest vote, reshaping society in ways no citizen would have ratified if asked directly. The genius of revision is that it never looks like what it is. It looks like paperwork, like housekeeping, like lawyers organizing old statutes into neat columns. But its effects are still with us, written into laws, written into institutions, written into the country itself. This is the story of how revision displaced democracy and why it still matters and impacts us today. A history of revision. In 1545, a physician named Thomas Renaud sat down to translate a German medical text into English. The original had errors, mistakes in dosages, anatomical confusions, the kinds of things that could kill a patient. So Renaud did what scholars do. He corrected the text. He improved it. He looked it over again. He revised it. For the next 100 years, that's what the word meant. To revise was to examine something a second time, to catch what you missed, to make a text more accurate, more useful, more true. It was a scholar's word, a printer's word, a word for people who cared about getting things right. No one imagined it could ever be used to unmake a nation's laws. Accumulating laws. Now, let's go forward a little over 100 years to 1649. For centuries, Parliament had been passing statutes, hundreds of them, then hundreds more. Laws piled on top of laws. Some contradicted others. Some had been forgotten entirely, and the language itself was a barrier. Court proceedings were still conducted in law French, a dialect that hadn't been anyone's native tongue for 300 years. For most of English history, this chaos served a purpose. It kept legal knowledge in the hands of lawyers. It made the common people dependent on professionals who could navigate the maze. But in January 1649, something unprecedented happened. Parliament put a king on trial, found him guilty, and on the 30th day of January, executed him. Now the men who had killed a king faced a question. What do you do with the king's laws? The First Revision Committee. On an unrecorded day in 1650, Parliament appointed a committee. Its mission, recorded in the parliamentary records, was to revise all former statutes and ordinances now in force and consider, as well, which are fit to be continued, altered, or repealed, as how the same may be reduced into a compendious way and exact method for the more base and clear understanding of the people. So reading that with a closer eye, not to correct the statutes, not to fix errors, to decide which are fit to be continued and which should disappear. The chairman was Bulstrode Whitlock, the Lord Keeper of the Great Seal, the man who held in his hands the physical stamp that made law official. No grant, no commission, no treaty was valid without the impression of that seal. Whitlock was, in essence, the gatekeeper of legal authority itself, a man who had opposed the king's execution, but made his peace with the new Commonwealth because, as he saw it, someone had to keep the government running. Whitlock's committee was empowered to consult with judges, to call in any experts they needed, to prepare their recommendations for Parliament. They were, in essence, being asked to decide which parts of English legal history would be remembered and which would be forgotten. And the word they used for this work was revision. The Hale Commission. 2 years later, in January 1652, Parliament went further. They appointed Sir Matthew Hale, one of the most respected jurists in England, to lead a commission on law reform. The Hale Commission met 3 times a week. It included 8 lawyers and 13 laymen, and its proposals were, for the time, radical. Reduce the use of the death penalty, allow defendants to have lawyers in criminal cases, create county courts so ordinary people didn't have to travel to London for justice, establish a court of appeal. The commission produced 16 bills. It represented the most serious attempt at legal reform England had ever seen. Not one of those bills became law. Why? Because the lawyers in Parliament, the very men who had called for reform, discovered they didn't want it. The chaos of the old system was their livelihood. Bulstrode Whitlock himself, despite chairing the revision committee, spoke against reforms that would have simplified the Court of Chancery. When Oliver Cromwell pushed for change, Whitlock pushed back. Here was the first lesson about revision. The men who control the process can stop it. The Ghost Statutes. But Parliament during this time did pass laws, lots of them, over 1,200 ordinances between 1642 and 1660. Laws governing trade, laws about religion, laws organizing local government. The Navigation Act of 1651, which required that goods imported to England be carried on English ships. This was a direct strike at Dutch commercial dominance that would help build the British Empire. The first relief acts for imprisoned debtors, civil marriage ceremonies, the abolition of feudal tenures that had allowed the crown to extract payments from landowners. These weren't theoretical proposals. They were functioning laws. People lived under them. Courts enforced them. Commerce adapted to them. And then, in 1660, a single legal fiction made them all disappear. The Restoration's counter-revision. On May 8, 1660, the Convention Parliament made a declaration. Charles II, it announced, had become king immediately upon the decease of our late sovereign, Lord King Charles, on January 30th, 1649. Think about what this meant. The 11 years between the execution of Charles I and the return of Charles II, the Commonwealth, the Protectorate, everything Oliver Cromwell built, had never happened. Legally, constitutionally, officially. That period just didn't exist. The principle was followed with what one historian called relentless precision and thoroughness. The Cromwell years were counted as if Charles II had been reigning since 1649. The year 1660 was declared the 12th year of his reign. English law didn't count years the way we do. It counted by reigns, the 5th year of Elizabeth, the 10th year of James. Now the official calendars were rewritten. 1660 became the 12th year of Charles II's reign. The 11 years in between simply ceased to exist. All 1,200 ordinances, every law passed without royal assent, void, not repealed. That would have acknowledged they had existed, but simply void, as if they had never been written. The statute book, the official record of English law, went blank for 20 years. Open it today at a law library in Great Britain, and you'll find the 16th year of Charles I followed immediately by the 12th year of Charles II. The gap is silent. The pages that would have recorded Cromwell's laws are simply not there. Some records were burned, literally burned, by the public hangman, as a statement of what the new regime thought of the old one's pretensions. The scalpel, not the axe. But here's where it gets interesting. Here's where revision reveals itself not as a blunt instrument, but as a surgical tool. The Restoration government faced a practical problem. For 11 years, people had been buying and selling property. Courts had been deciding cases. Contracts had been signed. Debts had been collected. Marriages had been performed. If everything from the Cromwell years was void, England would collapse into chaos. Every property title would be questioned. Every court judgment would be relitigated. So Parliament passed the legal proceedings during Commonwealth Act of 1660. Its purpose? To legitimize the outcome of judicial proceedings during that period. Private lawsuits? Valid. Property transfers between private citizens? Honored. Court judgments in ordinary cases? Confirmed. But notice what was not saved. The laws themselves. The Act validated results while denying the authority that produced them. You could keep your house, but the government that had protected your right to buy it had never legitimately existed. And the lands of the crown, the lands of bishops and cathedrals that had been sold off during that period, those sales were declared void. That property went straight back to its original owners. The revision protected what the new regime wanted protected. It erased what the new regime wanted forgotten. And it drew the line exactly where power demanded, not where history actually had it. The Act of Oblivion. Parliament didn't hide what it was doing. It announced it in the very title of its legislation, the Indemnity and Oblivion Act of 1660. Oblivion. The long title spelled it out, an act of free and general pardon, indemnity, and oblivion. Oblivion, I can't say that enough. The word itself was the point. The act pardoned most people who had taken the wrong side during the Civil War, with notable exceptions for the regicides, the men who had signed Charles I's death warrant. But it went further than pardon. It mandated forgetting. Anyone who made malicious allegations or used words of reproach that revived the memory of the late differences could be fined. The Cromwell period was not merely to be forgiven, it was to be forgotten, and the legal machinery of the state would enforce that forgetting. The lesson. The word revision had traveled from a scholar's desk to the halls of power. Cromwell's men had tried to use it to purge the monarchy from English law, and largely failed, stymied by lawyers who preferred chaos to reform. The Restoration had used it to purge Cromwell from English memory, and largely succeeded, because those same lawyers found revision very useful when it served their interests. The tool was neutral, and the results? They depended entirely on who held it. And now this tool, this technique for controlling what a society remembers about its own laws, was about to cross an ocean. In England, revision had been used to erase a revolution, to make 11 years of history disappear from the statute books, as if the same had never been made. 3,000 miles away in the colony of Virginia, others were watching and learning. They would use the same tool, but not to erase a revolution, but to prevent one. The world before revision. To understand what Virginia's lawmakers did, you must first understand what they had to work with and what they lacked. Virginia in the mid-17th century, the 1600s, had no written constitution. There was no Bill of Rights limiting what the legislature could do. There was no Supreme Court to review the laws for constitutionality, because the Constitution didn't exist. The House of Burgesses was, for practical purposes, sovereign within the colony. What it enacted was law. What it revised was revised. This was not the system Americans would later create, a system of checks and balances, of separated powers, of constitutional limits on legislative authority. This was something older, a legislature that could rewrite the rules of society with no external check on its power. And the only constraint on that power was the common law, the centuries of English legal tradition that the colonists had carried with them across the Atlantic. The common law was not a constitution. It could not strike down statutes, but it did provide a default. When the legislature was silent, the common law filled the gap. For enslaved people, that default was their only protection. The uncertain world. In the early decades of Virginia, something surprising was true. The line between freedom and bondage was not yet a line of color. English settlers and those brought from Africa worked side by side in the tobacco fields. Both groups included indentured servants, people bound to labor for a term of years, after which they would be free. Both groups lived near one another, socialized together, sometimes married. Black Virginians appeared in court, sued their neighbors, testified in cases. Some acquired property. Some even owned indentured servants of their own. The first Africans arrived at Jamestown in 1619. For the next 40 years, their status remained genuinely uncertain. Were they servants or something else? Could they earn their freedom? What happened to their children? The legislature had not spoken clearly on these questions, and so the common law provided the answers. If your father was a free Englishman, you should be free. That was the rule of paternal inheritance, partis sequitur patrum, centuries old. If you were baptized a Christian, you could not be held in perpetual bondage. Christians did not enslave Christians. That was the ancient principle. If your term of service was complete, you were free. That was the law of indenture. These weren't radical ideas. They were simply English law, carried across the Atlantic, along with everything else. The common law's defaults left doors open. And in 1656, a woman named Elizabeth Key walked through one of those doors. Elizabeth Key. Elizabeth Key was born around 1630 in Warwick County, Virginia. Her mother was an African woman held in bondage. Her father was Thomas Key, a white English planter, a member of the Virginia House of Burgesses. Under the common law default, a child's status followed the father's. Thomas Key was free. Therefore, Elizabeth should be free. Thomas Key acknowledged his daughter. He had her baptized in the Church of England. And before he returned to England in 1636, he arranged for her care. She would serve as an indentured servant to a man named Humphrey Higginson for 9 years. When she turned 15, she would be free. But Thomas Key died shortly after making these arrangements, and the promises made on paper began to dissolve. Higginson transferred Elizabeth's indenture to Colonel John Mottram. The 9 years passed, then 10, then 15, then 20. Elizabeth Key, who should have been freed at 15, was still laboring in Mottram's fields at 30. When Mottram died in 1655, his estate classified Elizabeth Key not as a servant whose term had long expired, but as property, a slave. Elizabeth Key sued for her freedom. A jury of 12 colonists agreed with her. Elizabeth Key was free. But the estate appealed to the Virginia General Court, which overturned the verdict. Elizabeth was a slave, the higher court ruled, because her mother had been a slave. The case was brought to the Virginia General Assembly itself. A special committee was appointed, and that committee, after reviewing all the evidence, sided with Elizabeth. The committee's report stated plainly, by the common law, the child of a woman, slave begot by a freeman, ought to be free. They ordered that she be freed, that her former master's estate compensate her for the extra years of service, and that she receive corn and clothes. On July 21st, 1656, Elizabeth Key walked out of bondage a free woman. It was a victory for Elizabeth, but viewed as something else by the elites who ran Virginia at the time. The problem of defaults. Elizabeth Key's case revealed a vulnerability in Virginia's emerging system of racial bondage. The common law was still the default. When the legislature was silent, the common law spoke, and the common law, developed in England, where chattel slavery did not exist, kept leaving doors open. But here was the crucial difference between Virginia and the system Americans would later create. There was no constitution protecting these common law defaults. There was no Bill of Rights declaring that certain principles could not be overridden. There was no separation of powers preventing the legislature from simply rewriting the rules. The House of Burgesses was sovereign. If the common law left a door open, the legislature could close it. If a legal principle created inconvenient results, the legislature could revise it away. All it took was an active revision. The first revision, 1662. 6 years after Elizabeth Key won her freedom, the Virginia House of Burgesses passed a new law. The preamble was revealing. Whereas some doubts have arisen whether children got by any Englishman upon a Negro woman should be slave or free, there were no doubts. The common law was clear. Elizabeth Key's case had proved it. A child follows the father's status. The committee of the General Assembly itself had said so. By the common law, the child of a woman, slave begot by a freeman, ought to be free. But the Burgesses were not interested in following the common law. They were interested in revising it. Be it therefore enacted and declared by this present Grand Assembly that all children born in this country shall be held bond or free only according to the condition of the mother. The child follows the mother. This was not English law. It was not common law. It was not even consistent with the legal traditions the colonists had brought with them. The rule the Burgesses adopted came from a different source entirely, Roman civil law governing livestock. The Latin phrase was partus sequitur ventrum. That which is born follows the womb. Virginia's legislatures reached back to an ancient Roman doctrine about the offspring of cattle and applied it to human beings. Notice what happened here. The Burgesses did not merely pass a new statute alongside the existing common law. They revised the default itself. By enacting and declaring a new rule, they overwrote the common law principle that had protected Elizabeth Key and many like her. In a constitutional system with checks and balances, such a revision might have been challenged. A court might have asked whether the legislature had the power to overturn centuries of common law tradition, to violate an individual's rights. A written constitution might have declared certain rights beyond legislative reach. But Virginia had no such protections. The legislature was sovereign. What it enacted became the new default. The old rule that a child follows the father was not merely superseded, it was revised away, as if it had never been the law at all. The effect was immediate and devastating. Any child born to an enslaved woman would be enslaved, regardless of who the father was. A white planter could father children with enslaved women, and those children would be his property, not his heirs. The very biology of enslaved women became an engine of perpetual bondage, and the door that Elizabeth Key had walked through was now locked shut. The second revision, 1667. 5 years later, another doubt arose. Whereas some doubts have risen, whether children that are slaves by birth and by the charity and piety of their owners made partakers of the blessed sacrament of baptism should by virtue of their baptism be made free. Again, there were no real doubts. The principle that Christians should not enslave Christians was ancient. It had been part of Elizabeth Key's successful argument. Enslaved people who converted to Christianity had a genuine claim to freedom under English tradition. And again, the Burgesses moved to revise the traditional way. It is enacted and declared by this Grand Assembly, and the authority thereof, that the conferring of baptism does not alter the condition of the person as to his bondage or freedom. Notice the formula, enacted and declared. The Burgesses were not just passing a new rule. They were declaring what the law now meant. overriding the traditional understanding with a new one. The justification offered was remarkable in its cynicism, that diverse masters, freed from this doubt, may more carefully endeavor the propagation of Christianity by permitting children, though slaves, to be admitted to the sacrament. In other words, masters had been reluctant to let enslaved people be baptized because they feared it would lead to freedom. Now that baptism was legally meaningless, masters could baptize their slaves without risk. This was revision as redefinition. The Burgesses did not abolish baptism. They did not ban enslaved people from the church. They simply revised what baptism meant, stripping it of its legal power to liberate while preserving its religious form. The door was closed. Christianity would no longer set anyone free, at least not in Virginia. The pattern of revision. Over the next 3 decades, Virginia's legislators worked methodically through every remaining pathway to freedom. Each time they used the same technique: identify a common law default or traditional principle that might allow someone to escape bondage, then revise it away through statutory declaration. In 1669, they revised the meaning of murder. If a slave died during correction by a master or overseer, the act declared the death would not be considered murder. After all, no rational master would intentionally destroy his own property. Any such death must be accidental. Enslaved people were no longer persons who might be murdered. By legislative revision, they became property that might be damaged. In 1680, the Assembly revised the right of self-defense. Enslaved people were prohibited from carrying weapons, leaving their plantations without written permission, or lifting a hand against any white person, even in self-defense. And in 1691, the Assembly revised the possibility of manumission itself. Manumission, the voluntary freeing of enslaved people, had been legal in Virginia. Some masters did free people they held in bondage, whether out of conscience or gratitude for service, or because the enslaved person was their own child. The 1691 law didn't ban manumission outright. Instead, it revised the conditions under which it could occur. Any master who freed a slave was now required to pay for that person's transportation out of the colony within 6 months. Free black people, the Assembly declared, were a great inconvenience. They might harbor runaways, receive stolen goods, or influence enslaved people to resist. Better that they not exist in Virginia at all. Each of these acts followed the same pattern. The legislature identified a gap in the system, a place where the common law or traditional practice might allow freedom to leak through, and revised that gap to close it. The English complication. By 1700, Virginia's lawmakers had built an increasingly comprehensive system, but they faced a problem. English judges were not cooperating. In 1701, Lord Chief Justice John Holt, the highest judicial officer in England, ruled in a case called Smith v. Brown and Cooper. The question was whether a slave could be bought and sold in England like any other property. Holt's answer was emphatic. As soon as an enslaved person comes into England, he becomes free. One might be a villain in England, a serf bound to the land, but not a slave. This created a potential loophole. If an enslaved Virginian could somehow get to England, English courts might declare them free. But Virginia's legislature was sovereign within Virginia, and in 1705, they revised the loophole away. The Grand Revision, 1705. In 1699, the Virginia General Assembly appointed a committee of 9 men, 3 from the Governor's Council, 6 from the House of Burgesses, to undertake a comprehensive revision of the colony's laws. This was different from the piecemeal revisions of the previous decades. This was a general revisal, the same technique England had used in 1660 to erase the laws from Cromwell's period, the same technique Virginia itself had used in 1643 and 1662. The committee would gather every statute on the books, sort through the contradictions and redundancies, and produce a new consolidated code. They worked for 6 years, and in 1705, the General Assembly adopted the result. This was not merely a collection of existing laws, it was a replacement. The final clause of nearly every act in the 1705 revisal contained the same formula England had used. All and every other act and acts, and every clause and article thereof, heretofore made, for so much thereof as relates to servants and slaves, or to any other matter or thing whatsoever within the purview of this act, is and are hereby repealed and made void, to all intents and purposes, as if the same had never been made. As if the same had never been made. The exact language of erasure. The same words that had made Cromwell's Commonwealth disappear from English legal history, now applied to the laws of Virginia and to the ambiguities those laws had once contained, the 41 sections. The centerpiece of the 1705 revisal was an act concerning servants and slaves. It ran to 41 sections, the most comprehensive slave code Virginia had ever produced. The act collected everything that had come before: the 1662 rule of maternal descent, the 1667 rule that baptism does not free, the restrictions on movement and self-defense, the limits on manumission. But it did more than collect. It systemized, it hardened, it closed gaps the earlier piecemeal revisions had left open. All non-Christians brought into the colony would be slaves for life. All children of enslaved mothers would be enslaved. Enslaved people could not own property. Any horse, cattle, or hog found in their possession would be seized for the benefit of the parish poor. They could not testify against white people in court. They could be killed during punishment without legal consequence. And on Chief Justice Holt's ruling, the 1705 Code addressed it directly. A slave's being in England shall not be sufficient to discharge him of his slavery, without other proof of his being manumitted there. Virginia was declaring, in effect, we don't care what English courts say about slavery. We have revised our laws to create our own legal reality. The two categories. White servants, by contrast, retained extensive rights under the 1705 Code. They could not be whipped naked without a court order. They were entitled to adequate food, clothing, and shelter. At the end of their term, they received freedom dues, corn, money, and for men, a musket. They became full citizens, entitled to vote, own property, and participate in colonial government. The 1705 Code drew the line with surgical precision. On one side, people who happened to be serving a temporary term, after which they would join the community of free Virginians. On the other side, property that could be bought, sold, inherited, and worked to death, whose children and grandchildren and great-grandchildren would share the same fate forever. 41 sections, each one a brick in a wall. What was lost? Before 1705, the laws were scattered, inconsistent, sometimes contradictory. An enslaved person with a clever lawyer might find a gap, an ambiguity, a path to freedom. After 1705, there was only the code. The earlier Virginia, the one where Anthony Johnson, a free black man, owned land and cattle, the one where Elizabeth Key could win her freedom in court, that Virginia did not simply fade away. It was revised out of existence. The 41st section of the 1705 Code said so explicitly. All previous laws on these subjects were repealed and made void, to all intents and purposes, as if the same had never been made, as if the doors had never been opened, as if Elizabeth Key had never won. The difference from amendment. What Virginia did between 1662 and 1705 was not what Americans would later call amendment. Amendment implies a system with limits, a constitution that establishes certain principles as foundational, a process that requires more than a simple majority to change fundamental rules, a recognition that some things should be harder to alter than others, and for individual rights, completely unchangeable because they're simply self-evident, natural rights, speech, liberty, property, and life itself. Virginia had none of this. The legislature was sovereign. What the burgesses enacted was law, immediately and completely. There was no higher document to consult, no court to review their acts, no requirement of supermajority or popular ratification. Revision in this context meant something more radical than amendment. It meant the power to rewrite the defaults of society, to take principles that had seemed permanent and simply declare them void, to reach into the common law itself and extract the parts that created inconvenient results. Each revision did not change the rules going forward. It changed the legal reality retroactively. The common law principle that had freed Elizabeth Key was not overruled or extinguished or limited. It was declared never to have applied in the first place, as if the same had never been made. The template. Virginia had demonstrated something important. Revision didn't require a dramatic confrontation. It didn't require revolution or a civil war. It could happen quietly, over decades, through the ordinary work of legislative committees. Each individual act seemed reasonable enough. Clarify who inherits what status. Remove an obsolete provision about baptism. Consolidate scattered laws into a single code. Standard legislative work. But the cumulative effect was transformation. A society where black and white Virginians had once occupied similar positions, both potentially bound to service, both potentially free, became a society of permanent racial hierarchy, written into law, made to seem natural and inevitable. The old flexibility became invisible. The old possibilities became unthinkable. The code was all that remained. And this template, this method of using revision to close doors, while seeming only to organize and clarify, would not stay in Virginia. It would be used again in a new country where a Constitution and Bill of Rights was supposed to make such a thing impossible, where the legislature wasn't sovereign but rather the people. Those that applied the revisionist process hoped no one would notice. Unfortunately, they would be right for at least 200 years. But that's in my next episode, entitled An Empire State: How New York Established Second-Class Justice in America.